Welcome back to part two of our conversation with Attorney Matt Bracy. Again, the SEC and FINRA have issued an investor alert about selling pensions or structured settlement income streams. Matt Bracy is an attorney with the firm Nesbitt, Vassar McCown. He is considered an expert in the settlement purchase industry. He's been involved in it for the last 14 years. He is also the former president of NASP. Matt, welcome back. And again, in this part of the discussion, let's talk about people who are selling, for example, structured settlements. What should they know?
Right. Thanks, Scott, and thanks for having me back. It's unfortunate that the SEC FINRA bulletin was not more clear because there are some things that people who want to sell their structured settlement payment stream really should know. And there's lots of things. We could probably talk for quite a while, and you know, I have talked to lots of people about what they should know and what they should look for. But in general, I would say the first thing to do is when you are interested in selling payments because you have a need. And typically this is going to be an unforeseen circumstance that no one knew about when the structure was originally established. Because, you know, remember 95% by our estimates of people who are put in structured settlements, it works perfectly fine. They never have a need to sell payments at all. But for that 5% that do have a need, because of a changed circumstance, because no one sitting at a settlement table can predict the future, and you know, you're trying to predict out, you know, 10, 15, 20 years in the future, and you just don't get it right all the time. The fact that it's only 5%, in fact, speaks very highly of the structured settlement world, in my opinion. Nonetheless, when that circumstance does arise, there's a couple things to keep in mind. I would say the very first one is to shop around. And what I mean by that is there are lots of reputable structured settlement factoring companies out there. And you know, I think most consumers would be very well served to look at more than one, because you may want to, you know, see what kind of offer they make. You may want to see what kind of servicing and processing they do. You may want to just get a feeling for the people you work with. All those are very important, considering the longevity of the company, how long they've been in the business, considering their stability, considering how they want to structure the transaction for you. All those are important, and you don't really get a feel for that unless you shop around like any good consumer really probably should for anything. Get a couple of different opinions.
And finally, Matt, can you talk about the process in selling future settlement payments?
The second important thing I think consumers should know is that they're going to have to go to court, and I'm going to talk about that in a second. I want to talk about the process in just a second. But when they go to court, the real key inquiry by the judge will be whether or not this transaction is in the best interest of the seller, taking into account the welfare and support of any dependents. And so what I think that means is that there has to be a relationship between the amount of money you want to generate by selling payments. So let's say you're going to generate $40,000, and what you're going to do with it. And so you're going to pay debts, or you're going to pay for school, or you're going to buy a car, whatever it may be. But there has to be that relationship between the two. And that has to be explained in court. And the judge, I think the judge has to understand that well, because that's the basis for the decision whether or not to approve this. And so this tie-in between the need, an articulated need, and I would say a provable need. Think about evidence that you can present in court that shows you have this need, and the amount of money you're generating. That's one side of the coin. Scott, the other side of the coin is the idea of how much are you selling. I would suggest to you that if someone receives structured settlement payments of, let's say, $1,000 a month, and they rely on $600 a month to live on, basic living expenses, rent, food, etc., that $600 is sacred, and I don't think anyone should be touching that. Now, if they have other sources of income, fine, take that into account. What I'm talking about is a real analysis of how much is being sold out of their monthly payment or what have you. And some aren't just monthly, some are lump sum payments also, which are a little bit different character. But a real analysis of what position is this person going to be put in after the sale? Can they maintain their standard of living and so forth? And what do they need the money for? So that's the second thing to think about, is this relationship between what you need to do with the money and how much you're generating, and the financial condition you're going to be in afterwards. Very important considerations. Any good factoring company is going to work through that with you, but that is something important to consider. And then the third thing is, I do think it's important for sellers of structured settlement payments to understand the process and the timing. And I'll tell you that this is a little bit unfortunate, because I think when people have a need to sell payments, they don't need it in the future. The need is present and is right now, and I understand that.
And finally, Matt, can you talk about the process in selling future settlement payments?
This is a little bit of a lengthy process. Because of the court approval required, it can take, let's say at a bare minimum 30 days to a more average of somewhere around 70 to 90 days to complete a transaction. Keep that in mind. That is a fact of this. Now, oftentimes some companies will advance money ahead of time to help people make ends meet, but it won't be the full price. That needs to be kept in mind. That's important. The process is, once you've reached an agreement on how much you'll sell and for what amount of money you'll generate. So I will sell these payments, and I will, in exchange for that, I will get X dollars in a lump sum. Once that agreement has been made, then the next thing that happens is you'll receive a disclosure statement. The disclosure statement is required by laws, and it will be sort of like a truth in lending statement when you buy a house. It'll be really sort of the nuts and bolts of the transaction. They're all mandated by state law, and so they also contain some extraneous, in my opinion, some extraneous information that's a little bit confusing. We could probably talk about that in a different segment. But you'll have the sort of the nuts and bolts of the transaction laid out in a disclosure statement. After the disclosure statement, and there'll be a period of time where you have to wait, typically in most states, before you can sign a contract, but the contract is next. And the contract should contain the agreement that you've made. And so it'll talk about how many payments you're selling and for what amount of money. And that's the binding contract. And they're typically, they're not short. They're probably, I think industry average is probably somewhere around 12 or 14 pages. Read them carefully. Part of this whole process also is to be advised that you can seek independent professional advice. And in most states, you can elect to either receive that advice or waive the right to receive it. I think it's a good idea to consider professional advice always for these transactions, but it's an expense. You may not want to have that expense. And in most states, that's your choice. So after the contract and the advice, and then the next step after that is the court approval process. And so that means in most states actually going to court. And again, the factoring company will work with sellers on this, and whoever their local counsel is where the person lives will also work with them on getting them ready for the court experience. And it's typically a fairly short hearing in open court. And this is where the judge has to decide whether or not this is in the best interest of the person selling. And so it's important to be ready for that and to be ready to talk to the judge about why you need this transaction to happen. The lawyer who's there typically will be the lawyer for the factoring company, not your lawyer. So you really need to stand up and state why it is you need this. One of the attorneys I work with who does go to court on these frequently mentioned to me the other day that he told the seller, this is where you need to pick up your shield and sword and get ready to fight. And I think that's a pretty good analogy that really stuck with me. This is where you need to prove to the judge this is the best thing for you. And hopefully the judge will see that, and if it's the right transaction, then it'll be approved. So those are things that I think sellers should know about the process. I wish that the SEC FINRA bulletin had been a little more helpful in this regard, but hopefully this helps and clarifies some things.
All right, Matt, thank you.
Thank you.
Again, my guest has been Matt Bracy with the firm Nesbitt, Vassar McCown. This is the Factoring Channel, an affiliate of the Legal Broadcast Network.